Presidency directs immediate gazetting of presidential order as National Assembly commence decision.
President Buhari receives African Export-Import Bank officials' requests for alignment of lending scheme with Nigeria's agricultural priorities.
United States announces humanitarian support towards development of the Northeast.
On Good Morning Nigeria today, we focus on administration of justice in Nigeria, plus the Super Eagles and the FIFA World Cup, Russia 2018.
For some time now, the issue of administration of justice has been on the front burner in public discourse in Nigeria.
That's right, Joy. Now, the discourse obviously covers challenges associated with justice delivery in the country. And these include undue delay, integrity questions, inadequate manpower as well as facilities, plus general weak institutional capacity.
That's right, Kingsley. Now, in recognition of the importance of effective administration of justice as a cornerstone of good governance in Nigeria, the present administration adopted a national policy on justice.
Now, the policy, among other objectives, is aimed at addressing inefficiency with a view to ensure reforms in the justice sector, and then that these, of course, are in tandem with best practices.
The question now is, what is the situation with the administration of justice in the last few years? How effective is the national policy on justice in facilitating justice delivery in the country? And what innovative approach is necessary to fast-track justice delivery to sustain good governance in Nigeria?
Indeed, also, what, Joy might just say, what is the state of the rule of law in Nigeria?
That's right.
That's one pertinent question we'll be asking our guests in the course of our conversation segment. And of course, as the World Cup kicks off next week, we beam our searchlights on the Mondial. Now that the Super Eagles, that's Nigeria's national team, have concluded their pre-World Cup friendlies. Two topics for discussion this morning on Good Morning Nigeria. It's our pleasure to welcome you to the program. My name is Kingsley Osadolo.
And I am Joy Usiago. Good to have you join us on Good Morning Nigeria, broadcast live on the network service of the Nigerian Television Authority, the NTA, in Abuja, Nigeria's capital city. As always, the complimentary part of the program shall be brought to you, including newspaper review, business, sports, foreign and entertainment news. The morning news is right now with Hadiza Najatu Tijani. Hello, Hadiza.
Hello, Joy. Good morning, and here is the morning news. President Buhari has directed an immediate gazetting following his declaration on Wednesday that henceforth June 12th be observed as Democracy Day in Nigeria and that some heroes of democracy be given national honors. President Muhammadu Buhari has directed the Attorney General of the Federation and Minister of Justice, Malam Abubakar Malami, to take immediate steps to publish the presidential order in the Federal Gazette as follows. Chief MKO Abiola, Grand Commander of the Federal Republic, posthumous. Ambassador Babagana Kingibe, Grand Commander of the Order of the Niger. Chief Gani Fawemi, Grand Commander of the Order of the Niger, posthumous. The President also directed that this should be done so that the awards slated for June 12, 2018 can go on as planned. Meanwhile, the Senate has commended President Muhammadu Buhari for declaring June 12th as Democracy Day. Contributing to the motion by Senator Olariwaju Tejushu from Ogun State, the senators described the president's decision as a process of national reconciliation.
What he has started took us 25 years to achieve.
What the president did, the president meant well.
Similarly, the House of Representatives also applauded President Buhari for declaring June 12th as Democracy Day on the grounds that constitutional provisions for May 29th has to be amended.
For recognizing June 12th as the National Democracy Day in Nigeria,
I want to believe is a very serious and a very good handshake across Niger.
The federal government says it is determined to enhance economic cooperation between Nigeria and the Republic of Tanzania for the benefit of both countries and their citizens. President Muhammadu Buhari stated this at an audience with the new High Commissioner of Tanzania to Nigeria, Muhyiddin Moweto. The president also received a letter of credence from the ambassador of the Republic of Korea to Nigeria. He commended the Korean government for its educational programs in Nigeria. President Muhammadu Buhari is requesting the African Export-Import Bank to align its lending schemes with the agricultural priorities of Nigeria as the biggest beneficiary of the institution's loans and facilities. This was while receiving the president of the bank and chairman of its board of directors at the State House. Now, the visit of President Muhammadu Buhari to the United States is already yielding positive results, as the U.S. has announced a donation of $102 million humanitarian support towards the development of the Northeast. U.S. Ambassador to Nigeria, William Stewart Simonton, conveyed the message at the National Conversation on the Humanitarian Development Peace Nexus in Abuja.
Priority is being given to programs that focus on rehabilitation and resettlement, peace building, security, infrastructure, and social services, as well as resilience building.
It is about changing lives, transforming hope into something tangible.
The Nigeria Customs Service has recorded more than 1 trillion naira revenue generation in the year 2017. In the month of May this year, it has generated 101 billion naira. Lauding this performance, Vice President Yemi Osinbajo at the Nigeria Customs Service College graduation in Abuja says the service should brace up, as its role now will also involve facilitating investment.
We have reduced processes and documentation required for import and export. We're also on the threshold of launching the National Trade Platform. This is the integration of all port and customs processes and documentation through a single window. This is bound to remarkably cut down processing times for all inward and outward trade.
President Muhammadu Buhari has reaffirmed the commitment of his administration towards stabilizing the country and making it more functional and responsive to public aspirations for a sustainable future. The president stated this while hosting the nation's youth and artists to the breaking of Ramadan fast.
180 million. We are almost the rest of African states put together. I think the expectation is very, very high. So the pressure here is tremendous. But I cannot complain because I asked for it so many times. We are trying very hard to normalize the situation in the country.
You are doing a lot to take us to the promised land. Sincerely, we believe in you, and the creative industry also believe in you.
This is a government for the people, by the people, and we are deeply appreciative of the fact that you carry it along.
That's the news for now. Good morning, Nigeria continues with Kingsley and Joy after this break.
Unemployment, notably youth unemployment, features strongly in our party's manifesto. We intend to attack the problem frontally through revival of agriculture.
The 30K is going a long way. Actually, I bought an acre of land for 60K like 2012, and presently I have a cassava farm and a yam farm.
Reorganized, trained, and fully equipped, we are the new improved Nigeria Police Force. We fight crime, we bust syndicates. Whatever the crime, wherever the hideout, the Nigeria Police Force will get you busted. Stop kidnapping, armed robbery, murder, pipeline vandalism, and other criminal activities. Be productive. Be security conscious. Join the police force to secure your life and property. This message is from the Nigeria Police Force Public Relations Department.
The choice of who you marry in life must come from your friends.
You don't reach time where we suppose arrange wife give birth.
No, it must come from your mother.
She's your wife.
Can that thing called love blossom from an arrangement?
It's a different ballgame from a partnership in a conjugal relationship.
Can brides and grooms be truly happy with a stranger forced on them by parents or relatives?
I don't even know him. How can I marry him? I paid your bride price, and your father collected a piece of land from me.
Your rib-cracking comedy tries to answer these questions and serve them with a lot of rib-cracking comedy to you.
Is marriage by force?
Join us this week on Professor John Bull in the episode titled Arranged Marriages.
Thanks for the gift you bought me.
I should be the one thanking you for sending me a gift.
But I never sent you a gift.
I want a piece.
Oh no.
Yes. They will hold the piece.
Over and
Brought to you by Glow.
The largest data network, Glow Unlimited.
The smartphone network.
Sore throats, it's often caused by bacteria and viruses. Feels like they're having a party. You need Strepsils. It soothes the pain, plus it fights the germs with 2 germ-killing actives. Double power in 1 lozenge. Bye-bye sore throat. Take Strepsils.
Your perfect family is under threat by germs. Infectious diseases are now the world's biggest killer of adults and children. Every day, 16,000 children under the ages of 5 and thousands of adults die from infectious diseases. These infectious diseases are caused by germs. They are everywhere. An average human being comes in contact with over 1 million germs daily. In unclean water, dirty surfaces, in the toilet, on cuts and wounds, on your clothes. Germs can cause deadly diseases like typhoid, diarrhea, flu, and cough. To protect your family from germs, use the power of Dettol's 1 Cap Full for surface cleaning, in your bathing water, in your laundry water, for first aid, to protect your family from up to 100 illness-causing germs. Be Dettol Sure. Endorsed by the Nigerian Medical Association.
Thanks for staying with us on Good Morning Nigeria. For some business news, let's invite Kunle Adeyeye.
On the business news today, the United Nations Conference on Trade and Development has released World Investment Report for 2018. According to the report, investment trends and prospects shows that global foreign direct investment (FDI) flows fell by 23% to $1.43 trillion. Inward FDI flows to developed economies fell sharply by 37% to $712 billion. The FDI flows to transition economies declined by 27% to $47 billion, while projections for global FDI in 2018 show fragile growth. The report revealed that FDI activity was lower across all sectors as the sharp fall in the global FDI contrasted with the trend in other cross-border capital flows. FDI remains the largest external source of finance for developing economies, while the rate of expansion of international production is slowing down. However, growth in global value chain has stagnated. In another development, the federal government's voluntary assets and income declaration scheme (VADS) has recovered a total sum of 30 billion naira from taxpayers who have declared their assets under the scheme less than 3 weeks to the expiration of the tax amnesty. The Executive Chairman, Federal Inland Revenue Service (FIRS), Mr. Babatunde Fowler, stated that through the implementation of the scheme, the FIRS had been able to increase the number of taxpayers from about 14 million before 2016 to 19 million in 2018. The FIRS boss said some states had achieved significant progress in compliance rates under the scheme. Meanwhile, the Central Bank of Nigeria has rolled plans to issue 1.1 trillion naira worth of treasury bills in the next 3 months. The Apex Bank, in its third quarterly NTBS issuance program released this week, states that the 3 months bill to be issued represents the amount of bills that will mature during the period. This consists of 44.9 billion naira worth of 91 days bill, 225.1 billion naira worth of 182 days bill, and 782.5 billion 364 days bill. While bills to be offered next week comprises 6.2 billion naira worth of 91 days bill and 174 billion naira worth of 364 days bill. Next is a graphic representation of trading figures on the floor of the capital market. With business news, I'm Kunle Adeyeye.
All right, thank you very much, Kunle, for the business package. Next for us now, we'll take on the review of the newspapers that we have with us.
Our newspaper reviewer, Bayo Atoyebi, is in the studio. Good morning, Bayo.
Good morning, Joy. Good morning, Kinsley. Good morning, Nigeria.
See you.
Thank you.
There are matters arising from June 12th, even though...
Yes, and incidentally, 4 days to June 12, 2018, and June 12 ever controversial.
Absolutely, pleasantly so this time around in 2018. Let's take a look. All the front pages have stories on the presidential proclamation on June 12, as well as the honorees of this year's occasion. That Nigerian Tribune is the first paper we're taking a look at. Nigerian Tribune says reps in rowdy session over June 12 declaration. You have a number of riders there. Release June 12 election results. Senate tells INEC. Release June 12 election results. Senate tells INEC. We were not in charge in 1993. INEC. Abiola and Fawayemi families accept honors. Thank Buhari. Adebajo, Tinubu, Akeredolu, Barabe Musa, Kokori, and others react. And Buhari directs immediate gazetting of order. The stories, together with the riders, can be found in greater detail on pages 8 and 9 of the Nigerian Tribune. And let's also come to the Blueprint newspaper. Blueprint newspaper has it as its lead story. And it says with a double-decker headline, Senate wants Abiola declared president-elect. Endorses June 12 as Democracy Day. And of course, Buhari orders gazetting.
Kingsley, we also have the same story as lead stories in most of the papers here. Let's go to the pilot quickly. June 12, it comes with a couple of riders. Controversy trails Buhari's declaration of new Democracy Day. INEC must announce result of June 12 election, and that comment is attributed to the Senate. Wants salaries, entitlements paid to Abiola Kingibe. Reps kick as Buhari orders immediate gazetting of presidential directive. Afenifere says Kingibe does not deserve GCON award. You can find details of that story on page 4. And moving on to the Punch newspaper, it says, that's the lead story, Senate wants MKO Abiola declared as ex-president. Says INEC should release June 12 poll results. Reps in rowdy session over Buhari's declaration. Abiola's family, Mohammed Fawemi, thanked Buhari. Gazette June 12 Democracy Day order, Buhari tells AGF. And if you go to this day newspaper, we also have a similar headline. Abiola Fawemi families accept national honor, thank Buhari. We have 3 riders there. Senate 6 release of June 12 election results. Payment of entitlements to MKO Kingibe. House debates legality of making June 12 Democracy Day. Falana faults Belgore. President orders AGF to gazette decisions.
Well, Joy, there's no gainsaying the fact that the president's proclamation of June 12, henceforth as Democracy Day, has drawn serious interest. Former Chief Justice of Nigeria, Justice Alpha Belgore, said national honors could not be conferred posthumously. He was chairman of the 2016 National Honors Committee. He said he was not consulted. He said only soldiers and other servicemen, by virtue of 1964 National Honors Act, can be so allowed honored posthumously. However, some lawyers have taken a detour from that. They include Professor Isesage, another lawyer, Ulubode, and Lagos lawyer Femi Falana. And he says, with due respect to the former Chief Justice of Nigeria, the President can, as in paragraph 3 of the National Honors Act, allow the, clause allows the President the discretion to dispense with the clause of, that precludes the award to only those who are alive. He said the President may permit their family members to receive in their behalf. He said on the appointment, on the approval of the National Assembly, he signs the Public Holidays Act, which allows the President to appoint and approve a special day as public holiday, and therefore they argue it's in order. Meanwhile, a letter from the son of the late Mashood Abiola, Kola Abiola, says he appreciates the gesture as it is the right thing to do to right the wrongs that has bedeviled the nation, particularly those who are the nation builders and heroes that produce the democracy which we are all enjoying today. He said that he had written to the President 12 June 2016, and he now thanked the President for heeding our plea where others before you did not. Similarly, Mohammed Fawemi, the son of the late Senate Advocate of the Masses, Gani Fawemi, says the family will accept the honor. He says the family rejected the 2008 honor by President Umaru Musa Yar'Adua and 2014 posthumous award by President Goodluck Jonathan, because the family will now accept this one because this award take into cognizance the recognition of MKO Abiola, which is what his late father fought for. Meanwhile, at the National Assembly, there were also contention about this. At the National Assembly, Senator Dino Melaye was very vociferous, and he said, Mr. President, Chapter 43, subsection 2 of National Honors Act does not allow conferment of honors on non-Nigerians. And he argued further, Mr. Abiola is dead, and that automatically makes him not to be a Nigerian. Senate President, after several debates, ruled that he enjoined members to consider the gesture and therefore correct any legal impediments. At the House of Representatives, the debate was mildly rowdy. However, the debate was suspended by Speaker Yakubu Dogara, who directed the House Committee on Justice, Rules and Business to guide the House on the context of the public holiday. Guess what? Governor Ayodele Fayose says the president's action, though political, is the right step in the right direction. On this, these are one of the few occasions that the governor of Ekiti State has agreed with the president. You recall when the president directed the Federal Executive Council to have a detour of the new standard gauge rate to pass through Ekiti. He silently appreciated that. And this time he says the president should be courageous to order the declaration of June 12 election results and declare Abiola winner. Meanwhile, the president has directed the Minister of Justice and Attorney General to ensure the gazette of the statement.
All right, as we said yesterday, when we were reviewing the papers, when the story first broke, there are a number of matters that will arise from the president's pronouncement. There are legal issues, of course. We have seen that we have had a lot of support, from a broad spectrum of interest groups across the country, or stakeholders, to use the particular expression. But there are issues, of course, that will pertain to the declaration, official declaration or announcement of the June 12 election results. One point to note is that the results of the election were in the custody of the chief returning officer. And the chief returning officer had begun the announcement of the results of the June 12 election when he was stopped, if you like, in mid-sentence. So I think that these are issues that the chief returning, the chairman of INEC at the time was Professor Humphrey Wonsu, who is still alive. It wasn't INEC. It was called
to come and complete his assignment.
It was called the National Electoral Commission. I think for the sanity of the country, as one of our guests mentioned yesterday, when we were discussing the topic, these are matters that, of course, will engage the nation's attention in the coming days and weeks and perhaps months. All right, Bayo, let's take other headlines from Blueprint newspaper. Above the nameplate of Blueprint, NLC reports federal government to ILO over what it calls planned proscription. 55 Mina jailbreak inmates rearrested. That's according to the prison service. And below that, you have some other headlines. Inspector General of Police wants court to quash Senate's incompetent resolution. That's the resolution of the Senate describing him as, according to the Senate, incompetent. That story is in greater detail on page 13. Deputy Speaker Lasun Yusuf joins Osun governorship race. Family of 5 and friend die after moving to own house. Details of that story can be found on page 8. And very quickly from the Nigerian Tribune, let's look at the panel of headlines on the first column from the left-hand side. Of our bank robbery, there's an update there. Saraki sends response to Inspector General of Police. And also the family of 5 dying hours after moving to new house. That's on page 33. And of course, IGP takes Senate and Saraki to court for declaring him enemy of democracy. Oshibajo's helicopter in emergency landing, that's page 2. And threat from Nigerian military won't deter us from defending human rights. That's according to Amnesty International.
Let's move quickly to the Punch newspaper. Above the nameplate, we have a couple of stories. Offer robberies have sent written defense to the police, says Saraki. You can find that story on page 20. CBN set to begin Chinese currency sale. Details on page 25. And Senate Saraki have hatred, contempt for me, says IG. Details of that can be found on page 10. And at the foot of the front page, let's see some of the stories we have there. Senate reverses Rex confirmation, approves Kafarati as FHCCJ. Don't write off Super Eagles, says Roy. And customs generate highest monthly revenue of 100 billion naira. Details of that story can be found on page 23. And moving on quickly to this day newspaper, below the lead story is this one, which says CBN to commence bi-weekly auction of Chinese yuan. You can find details of that story on page 12.
All right, Bayo, just before you come in, let's take the editorial from the Daily Sun. The editorial is on page 15 of the Daily Sun. It says special funding for security agencies. And the very first paragraph first paragraph and first two sentences. So the recent resolve of the National Assembly to approve special funding for the nation's security forces is understandable, considering the spate of killings and insecurity across the country. However, such funding, according to the Senate, will be different from the annual budget of the agencies.
Well, let's quickly look at the update on offer robbery. Dr. Bukola Salaki says he has given his response and explanation to the police regarding the alleged links of him with the offer robbery suspects. And he tweeted, in line with their request, earlier Thursday, police received my response to their letter on the investigation in the offer robbery case. Meanwhile, the Inspector General of Police too has gone to court. He filed a suit seeking a reversal of the Senate declaration of him as incompetent and also as an enemy of democracy. The third one that you drew attention to, the family that moved to his house, a new house, and died. Apparently, they moved in after they have fumigated the house. And that is something that many of us take for granted. We tend to drop poisonous substances in the ceiling of our house or the fumigation without allowing enough time for those dangerous, toxic elements to peter out before we get in. And they tend to have serious consequences. In fact, the most dangerous are the local one that is called otapiapia. Many of our people drop it on the ceiling, and they don't know that gradually it percolates from the ceiling gradually into the home, and it has serious consequential effect, toxic effect on persons. And we need to be very careful about it. Now the editorial. Special Forces Security, you recall that the Senate in its wisdom invited the security chiefs, particularly in view of the security challenges we are having across the country, killing, armed robbery, kidnapping, banditry. And they said they considered that they will approve a special fund for the security. And the editorial is saying that, yes, naturally, the budgetary provisions may not be enough, and therefore, it is quite in tune with wisdom for the Senate to provide special fund for the security. However, they admonish that those funds should be used judiciously, particularly talking on providing equipment for the armed forces. Also, it addressed specifically empowering what he described as our weak police to ensure that they get up to standard. We are taking instances from what happened in the past. It is alleged that a lot of money meant for security from the Office of the National Security Advisor find its way into political terrain, and that should not be allowed to happen this time around.
That's right. And some former top brass of the military are also undergoing trial.
Yes.
For the allegations.
Huge sums found in Sokaways, allegedly.
And some other locations. Baya Toby, that's the much that we can take today. We would like to appreciate you for being with us, not just today, but indeed all through the week. The commander of Newspaper Review.
Thank you very much.
We will gazette it.
I thought it was a joint exercise we review together.
We will gazette it in the NTA, in the NTA journal.
Thank you very much.
Thanks a lot for being around. See you on Monday. All right, so it's Good Morning Nigeria. We'll take a short break now. When we return, we are dealing with two topics, administration of justice in the country, plus the Super Eagles and World Cup kicking off next week.
Hate speech is not a joke. It incites genocide and crimes against humanity. Most of Africa's civil wars are caused by hate speech from one tribe against another. We don't want it here. The Nigerian government stands firm against hate speech.
Under no conditions whatsoever should we tolerate or excuse or justify hate speech or hateful conduct of any kind, especially where such is illegal.
There's no doubt that the resurgent push for separatism, as well as the rising cases of ethnic and religious disharmony, are all traceable to the growing phenomenon of hate speech.
One nation bound in freedom, peace and unity.
Nigeria, one nation, one people.
This is a public service announcement brought to you by NTA.
Dettol team is visiting schools to teach children how to protect themselves from diseases. Do you know how we get illnesses like diarrhea, cough, and cold? No! They are spread through germs which are everywhere. You collect germs that cause diseases. You pick up germs from any surface, like when you don't wash your hands after going to the toilet, while playing. And then you can get sick because of germs. That's why you need to fight germs to stay healthy by washing your hands and taking your bath with Dettol soap to protect from up to 100 illness-causing germs.
Wash, wash, wash your hands. What you have to do is bath, bath, bath yourself. Dettol soap every day. Wash, wash, wash your hands.
The NTA Television College Jos admission forms for diploma program in film and television production, television engineering technology, broadcast journalism, and degree programs in mass communication, television journalism, and mass communication television production is now on sale. The sale of forms will commence 14th May and run to 13th August 2018 at the cost of 7,500 Naira only per form, payable through the remitter platform in favor of NTA Television College Jos. Forms can be obtained from all marketing offices in NTA State Capital Stations, zonal centers, Training Directorate of the NTA Headquarters Abuja, and the Office of the Academic Secretary of the NTA Television College. Applicants are required to possess 5 credits in GCE, SSCE in relevant areas of study, including English and mathematics, in not more than 2 sittings. All completed forms attached with photocopies of credentials must be submitted on or before the 13th of August 2018 to the stations where the forms were obtained. For further inquiries, please contact the Office of the Academic Secretary on these numbers. Announcer, Registrar.
Madam. Brought us as usual.
As usual. You have no problem.
For the three put
you are welcome, sir.
As usual, yeah?
Welcome. You take that one. Yeah, take that one. You don't understand? We want Nigerian homegrown rice. Finish. You don't have? You don't have?
Join the rice revolution today.
No other rice that tastes like Nigerian rice. Are you sorry? That's the Nigerian rice we are talking about. Chocolate made in Nigerian rice. Healthy food. I'm going to bring Mrs. Mobu to come to chocolate rice of made in Nigeria here. And see how it are made.
Correct.
And how they are cook it.
Correct.
Homegrown rice are good for your health. It boosts our economy and give employment to our people.
This message is brought to you by the Federal Ministry of Information and Culture.
Thanks for staying with us. Let's take this background report put together by Mitaire Ikpeng to kickstart our discussion.
There has been hue and cry over the delay in the administration of justice in Nigeria over the years. Despite the passage of the Administration of Criminal Justice Act 2015, criminal cases still move at snail pace in various courts owing to a myriad of challenges. These challenges include lack of proper case management, unnecessary adjournments, and inadequate manpower. Furthermore, the Nigerian judicial system still falls short of applying information and communication technology to drive justice delivery, as judicial officers still rely on longhand to record proceedings and deliver judgments. In a bid to address these challenges, stakeholders in the justice delivery system last year adopted a national policy on justice as a way forward. The blueprint outlines the various reforms desirable in the justice sector to engender smooth, fair, just and transparent administration of justice in the country. The policy also provides the needed professional guidance for all justice sector institutions in the discharge of their duties. But how far can it go to correct the age-long delays and restore public confidence in the judiciary? This will form part of discussions on Good Morning Nigeria.
Thank you very much, Mitaire, for that background report. Now, joining us to discuss these issues in greater detail, we have the Attorney General of the Federation and Honorable Minister of Justice, learned Senior Advocate Abubakar Malami. Attorney General, pleasure to have you on Good Morning Nigeria again.
My pleasure.
All right. Also here with us in the studios, a regular guest on Good Morning Nigeria is the former Secretary General of Nigerian Bar Association, Mazi Afam Bosigwe. Mazi Osigwe, pleasure to have you on the program.
Thank you so very much.
All right, and also here with us in the Abuja studios, would like to welcome a legal practitioner, is Masood Alabelewe. Pleasure that you are with us on the program.
Good morning.
All right. And from our Ibadan Network studios, we have another guest. It's a former chairman of the Nigerian Bar Association Ibadan branch. He's Kazim Adekule Badamosi. Mr. Badamosi, pleasure that you are with us on the program this morning.
Yes, sir.
Let's begin the conversation first with the learned Attorney General of the Federation and Honorable Minister of Justice. Perhaps, let's take a panoramic view of what the state of the rule of law in Nigeria is at present.
Well, the state of things, in all sincerity, is apparently encouraging, is apparently not only encouraging, but then substantial and great improvements are being recorded on a daily basis as far as administration of justice in Nigeria is concerned. Looking at it from the point of legislations, for example, we have in place Administration of Criminal Justice Act, and among the major innovations that are created by the Administration of Criminal Justice Act are the speedy trials that allows day in, day out proceedings as it relates to criminal cases, for example. And a lot of other innovations that uphold the right of individuals as it relates to speedy administration of justice and access to justice. Further improvements that are equally encouraging are equally constitutional, for example. Of recent, you very much know that there are a lot of constitutional amendments that have been incorporated into the Constitution relating to expeditious and speedy justice delivery. For example, issues relating to stay of proceedings were captured, and a lot of other proposals that were canvassed and put across for consideration of the National Assembly by the judiciary as it relates to speedy dispensation of justice are equally captured in the constitutional amendment. Over and above that, on the part of the judiciary as well, there are a lot of other practice directions that set into the system over time that have the effect of expeditious determination of justice. Front-loading process by which parties in the process, in judicial proceedings are expected to put across their evidence ahead of the trial of cases have tremendously assisted in speedy dispensation of justice. So the scenario as far as justice dispensation is concerned is indeed very encouraging, against the background of the fact that necessary amendments, necessary improvements, and necessary inputs are being on a daily basis fine-tuned and put into the process that will allow for expeditious determination of justice and indeed access to justice.
Now, some of these new rules to remodel the justice system, despite what we have in place, and some people would still argue that we're still moving at a slow pace. What would be your reaction to such comments?
Well, my reaction to it, I think that assessment has to be rooted into the prevailing provisions of the law. As I stated earlier, if you are talking of preface, you have to now look at it from the perspectives of what obtains within the Administration of Criminal Justice Act. This is a situation that dramatically differs from what obtains before. The situation on the ground now is a speedy determination by way of day-in, day-out proceedings. So if you are talking of a day-in, day-out proceedings and juxtaposing it with a position that obtains before, whereby cases are adjourned to 3, 4, or 5 months, you understand, I think it is out of place to conclude to jump to that conclusion that things are still stagnated in terms of speedy administration of justice.
Well, of course, Honorable Minister, when you talk about the Administration of Criminal Justice Act, that of course relates to criminal proceedings, and equally important are civil proceedings and commercial proceedings. And one complaint that residents and indeed outsiders had often made had to do with the sanctity of contracts, as well as getting justice in the event of breaches. How much progress have we made, for instance, with regard to upping the dispensation of justice with regard to, say, commercial transactions?
Well, if you are talking of commercial transactions, for example, through effective collaborations with the judiciary and appreciation of the need for ease of doing business, for example, we are living witnesses to the fact that practice direction had indeed been issued by the judiciary, particularly the Chief Justice of Nigeria, to the effect that arbitration clauses in commercial transactions must be respected. Before the coming into effect of the practice direction in that respect, we were living witnesses to the fact that determination as to whether an action that is commercially based should be concluded within practicable time was as good as a mirage, in the sense that contention relating to whether the court could now decide on the arbitration or not could take ages, in some cases 10 and above years. Now, by that practice direction, once you have arbitration clause, it is sacrosanct. You must comply with it, and then the courts are now declining jurisdiction generally in situations and circumstances where you have an arbitration clause in an agreement. So, to the extent that our system, a judicial system for that matter, had now evolved in such a way and manner that it accords special consideration to the sanctity of the clauses in an agreement, coupled with the ease of doing business processes that are put in place by the government. I think we are indeed making substantial progress, even in the direction of commercial transactions and sanctity of contractual agreements as well.
All right, still back to the issue of the criminal justice system. Let's look at the value chain. Well, of course, you have investigation, you have issues relating to prosecution, prosecution which is also trial, and then ultimately sanction and imprisonment. Complaints continue to persist with regard first to the quality of investigations and ultimately also with regard to prosecution. Lack of diligent prosecution. We have seen a number of cases in recent times being, of course, thrown out on account of the weaknesses either in investigation or in prosecution. What is being done with regard to this to ensure that there is the justice of the cause in the particular circumstance?
Well, in terms of building capacity and institutions, for example, the federal government had indeed substantially evolved policies that has to do with the improvement on quality of investigation, quality of prosecution, and associated things. And these are indeed supported by necessary legislations that will see to ensure the improvement in the quality of prosecution, investigation, and associated things. As I stated earlier, if you look at the administration of criminal justice, before now, for example, cases are just taken to court, perhaps maybe at the pleasure and convenience of the prosecutor, who decides when to prosecute them and when not, and then incident applications for adjournments are almost becoming order of the day. Now, this is a legislation that insists that if you put in a case or place a case before the court, you must be prepared on a daily basis to prosecute it. And then with that consideration in mind, security has been provided by legislations for expeditious determination of cases. This is a system that has now, that is no longer giving room for delays as it relates to the fact that the prosecutors are not ready and prepared for the purpose of presenting the required evidence in proof of their cases. So to the extent that those elements of prosecution, those elements of expeditious determinations are factored into our legislations, I think we have, we have succeeded in bringing about policies, in bringing about legislations and legal frameworks that at the end of the day support the idea of placing the investigators, of placing the prosecutors, and indeed the judiciary. So the system is now put in a kind of situation that the delay element is substantially displaced by the fact that neither the courts nor the prosecutors or investigators are given the latitude of prosecuting cases at their own time. So the delay element is substantially been legislatively addressed, and I think that in a way has assisted in expeditious determination of cases.
Now, still talking about the issue of diligence in terms of prosecution, some school of thought would argue that because of some of these bottlenecks here and there, one can conclude that that probably has given rise to a level of impunity in the society. What's your take on that?
Well, my take is, generally speaking, you cannot conclude by way of saying that there are no impunities that are set in it. But then the question is whether those impunities are being addressed by the measures that are being taken in terms of the quality of legislations that are put in place. Take, for example, now the constitutional amendment that, somehow outlawed the possibility of stay of proceedings. Before now, you institute a case at the court of first instance, and then if the case now, the proceedings are commenced and you feel somehow it is not favorable to your interest, you take immediate steps to file an application for stay of proceedings. That singular application for stay of proceedings might be litigated up to the Supreme Court level, and that translates to about 10-15 years in point of time, not addressing the merit and substance of the case. Now, if by the constitutional amendment, that factor of stay of proceedings is eliminated, at least, is eliminated within the system of proceedings, I think you will readily agree with me that that, in a way, will assist in ensuring that justice is not only done, but then it is expeditiously done by way of allowing the determination of the merit of the case. So if you are going on appeal, definitely it will no longer be on the basis of stay of proceedings, but it will be on the basis of the merit of the case. So what I'm saying in essence, that honestly the system is evolving in terms of improvement, in terms of speed, in terms of quality.
All right, Attorney General, thank you very much. We'll come back to you. We earlier introduced your other learned friends who are here with us in the studios, as well as at our Ibadan Network Center. Let's bring in now Mazi Afamosigwe. Mazi Afamosigwe, the first question I asked the Attorney General, I'll also ask you. From your perspective, from the bar, where are we with regard to the rule of law as of today? And taking that question along with whether or not we are seeing law being effectively used as an instrument for social, economic, and political engineering or re-engineering.
Well, I would say we're not doing well. Well, there have been quite a number of legislative improvements, judicial pronouncements, which, like the Honorable Attorney General of the Federation addressed, have addressed issue of using interlocutory applications to stall trials. But it goes beyond that. If we focus on the judiciary, we'll make it look as if there are not other components that we'll look at in deciding whether rule of law prevails. Talk about policing, security agencies. What is the feedback? And talking about police, I do not know any lawyer in the last 1 year who has found it easy to enforce monetary judgments against the police. That's part of rule of law. It's difficult, even with TSA, it's difficult to get monetary judgments awarded by the court enforced. Now, because of belief by people that judicial trials cause delay, you see law enforcement agents take laws into their hands. You consistently hear stories of people being labeled Yahoo boys, taken in a bus, taken to a police station, and forced to an ATM to get money. You hear so many cases of people getting killed, herdsmen, farmer clash, people not being brought to book, because these are issues we must look at. You hear cases of alleged rape of IDP, people in IDP camps. If we concentrate on the courts without looking at other aspects of it, in law enforcement, relations of the civil populace to the armed forces, the ability to enforce court judgments, then also executive recklessness, where even some state executives refuse to respect court orders. The court says, don't do this, and a governor goes ahead to demolish a property or to do that which the court has ordered that person not to do. Because people feel that contempt proceedings cannot be brought against them, they cannot be punished, nothing happens to them. And then the court orders that a person be not arrested or a person arrested be released on bail. And an agency refuses to release that person. This is all important in determining to what extent is compliance with rule of law encouraging. If police can brazenly violate your rights, or if a lawyer goes to a police station to represent a client, even when the Administration of Criminal Justice Act which the Honorable AG has referred to, allows a lawyer to be present when his client is being questioned and his statement taken. And the police will brutalize the lawyer, arrest and detain him, or even charge him to court on trumped-up charges of coming to the police station to attack policemen. As ridiculous as that may appear, it touches on rule of law, because it erodes confidence in the populace. If your lawyer who comes to a police station, or indeed to any person to represent you, can be humiliated and thrown into cell with you, it makes people to believe that when the hunter becomes the hunted, the ability to get justice from such a place becomes a mirage.
So what exactly is in the system that is responsible for some of these challenges?
Now, because people do not see, they believe the state is not able to enforce some of this, or people are not interested, or that even when people go to court, nothing comes out of it. So it is a devil-may-care attitude of what can you do? And then people remove their badge. You see policemen and they say they are SARS. And they are not dressed any better than different from armed robbers. There's nothing that suggests they are policemen. They are out of uniform. They wear trainers. They wear chinos. They wear clothes that just any person can run out of the bush wearing. Extreme level of lawlessness, and people feeling that laws do not bind them and they cannot do anything. These are some of the issues.
All right, Mazi Afamosigwe, thanks a lot. We'll come back to you. Let's bring in now Masoud Alabelewe, legal practitioner as well, with us here in the Abuja studios. Let's have your take on the issues, of course, that have been touched on by the learned Attorney General of the Federation and your learned friend, Mazi Afamosigwe, with regard to the rule of law. Are we necessarily in a state of nature, or indeed, as the Attorney General of the Federation said, there are bright spots with regard to the rule of law?
Thank you very much. I will have to agree also that the level of sufficient compliance with the rule of law in this country still has much to be desired. Let me give you one of the tripod of the rule of law. All persons must be equal before the law. In this country, we have seen that there are quite a number of persons who feel they are above the law because they do things the way they want it and they get away with it most of the times. Now, you have heard about policemen, talking or inviting top-notch politicians, and a lot of things are going on in town about whether or not the police should do their job. You have had people being charged to court for being arraigned before a court, and you have their friends or supporters besieging the court to ensure that the place, is not accessible. Now, if all believe as the fact that we are all equal before the law, then you cannot say that because somebody was a former governor and he's been arraigned before a court and his supporters will go there. I was at the Federal High Court. I have to give specifics. I was at the Federal High Court yesterday to take a judgment, but I had a hectic time trying to enter the court because a former governor was coming back to court for an application for his bail. And throughout the proceeding while I was there, this crowd of mammoth supporters of the governor were just wailing and disturbing the atmosphere. Does it mean that because you have achieved the position of being a governor, are you above the law? Examples are bound of several persons who
who bears responsibility for the kind of crowd you are describing?
Well, I don't know who bears responsibility. I'm not sure that the governor might be the one that will have invited his people, but I, at some point, had to say, okay, maybe some of our colleagues should go out and maybe talk to them. Now, that was just a case that is in point. But then you find out that over the years, allegations are made against a common person, and he quietly answers his charges, defends himself in court. But when you're talking about highly placed persons in the society, one, he has the money to get the best of lawyers, and he goes to court to employ various kind of tactics to ensure that he escapes from justice. Now, this kind of thing, can you say that rule of law is being complied with when everybody doesn't see themselves as equal before the law?
All right, thank you very much, Masood Alabelewa. We'll come back to you in the course of our conversation. Let's go quickly to our Ibadan studio and bring in Kazim Adekunle Badamasi, who is the former NBA chairman, Ibadan branch. Thank you for staying with us, and I'm sure you've been following the conversation, and we're looking at the rule of law in Nigeria in the last 3 years and doing a constructive analysis of it. Let's hear your own view. Where are we? How have we fared in the last 3 years? Is it still business as usual, business unusual, or we're making steady progress?
Of course, I've been following the conversation. But you see, I quite agree with the Minister for Justice and Attorney General of the Federation on the issue of the legislations which we have had, which is encouraging. But the problem actually is the law will not operate itself. You need the men to operate the law and to make it effective. Without taking the statistics of what we are coming with or where we are coming from, you cannot understand the effectiveness of the law which has been passed. When we take the cases which we have had in the 60s, in the 70s, and the number of judges which we have had, the law was effective then. Even without the admission of criminal justice law in those days, cases were had timelessly. But with the explosion in population, the number of judges that we now have on the bench are not enough to handle these cases. And that basically accounted for why, for example, the election matters. You have special tribunals, you have special judges with special packages, and they have to sit late in the night. That was after the passage of the amendment to the Electoral Act, which says these matters must be completed within 6 months. So if you are going to talk about admission of criminal justice act or law, then you need men to be on ground to interpret the law and actually apply the law. For example, I will make an example of Oyo State, where you have a judge having about 300, 400 cases on his table, in his dock, in a year. You cannot expect that judge, even without stay of proceeding or stay of proceeding, whether there is stay of proceeding or there is no stay of proceeding, he cannot finish half of those cases in a year. So there is no way the justice system can say to have been fast-tracked. To fast-track it, you need certain facts, you need certain materials, you need certain things to be put in place. One of it is our AG, our Minister for Justice, has visited several countries. In those countries, you have legal research assistants that assist judges in carrying out their duties. Even when we watch the Oscar Pretorius case, you will see that our legal research assistants, there are facilities, there are machines which they could use, which could assist in dispensing justice. Are these all made available to all the high courts? You see, when you talk of justice system, you are not talking of federal high court alone. You can say in some federal high courts you have some of these materials. You have to take cognizance of the states, which is the high courts in the states, which are closer to the people. So in assessing justice, in determining whether justice is actually being done, or whether there is rule of law is being enforced or is moving at a fast track, you have to take cognizance of, 1, do we have the requisite number of judges? 2, do you have the requisite materials for the judges to dispense justice? If you don't have these, then definitely you cannot be talking of the admission of justice moving fast. The law is there, but who will implement it? When you don't have the necessary materials, enough materials, there is no way the law can be appropriately interpreted and dispensed. And that's one of the basic problems we have in the country.
All right, thank you very much, Mr. Badamasi, Kazim Badamasi. We'll come back to you. Let's return to our Abuja studios with the Attorney General of the Federation and Minister of Justice. You've listened, of course, to the comments. But one aspect, you will respond to the issue relating to the disobedience of court orders. But let me ask you to proceed further on the issue of proper facilitation of justice delivery. Usually from the states, you hear reports of the executive branch and the judicial branch of collaborating with regard to provision of infrastructure, employment, new facilities, and so on and so forth. How much of that are we seeing, for instance, at the federal level?
Well, in terms of advancing the course of administration of justice, as to what the federal government has done in order to advance the course of justice, for the first time in the history of Nigerian state, this is the administration that has accorded sizable improvement in the budget of the judiciary by increasing it, I am not sure, within the region of 20 billion per annum, compared to what of times before. The essence and spirit in which this is done, one, is to address the welfare of judges, two, bring about improvement in facilities and associated training and requirements of the judiciary for it to live up to its responsibilities in the administration of justice. If you are talking as well in terms of enforcement arising from the decisions of the court, for example, this is the first time ever in the history of Nigerian state that the federal government, under the leadership of President Muhammadu Buhari, is giving effect not only to the judgments of the court, but in fact even recommendations of the Human Rights Commission. I believe you are aware recently that the sum of 135 million naira has been paid in favor of the AFO6, arising from the recommendations, from the findings of the Human Rights Commission in respect of infractions that were carried out by a government before, by a previous government. This is the first time that people that were considered responsible arising from the APO6, the officers, particularly the security agencies, were indeed convicted for infractions of the rights of the people and individuals involved. Now, coming to enforcement as well, this is the first time in the history of Nigeria that the federal government is making sizable provision for the payment of judgment sums in respect of human rights breaches, contractual breaches, awards, and associated things. From 2015 to date, when this government came to office, around 20 billion naira has been paid in settlement of judgment debts. That in its right goes to establish the fact of, that the government, this government has respect for judgment and orders of the court. This government has respect for the dignity of human person. This government has regard and respect for human rights of persons. So within the context of enforcement, I think the government has not done very bad in terms of enforcement of the judgments of the court, in terms of recognition being accorded to the human right, to the decisions of the Human Rights Commissions and associated things. So within that context, within the context of the fact that sizable provision has equally been made to the judiciary to support and enhance its independence in terms of provision of training facilities and associated things, I think we have not done badly.
All right, thank you very much, sir. Let's bring in quickly Mazi Afam Osigwe into the conversation again. You listened to Kazim from Ibadan, and you also heard the Attorney General of the Federation. Now, Kazim raised a couple of issues touching on the number of judges and some of the challenges in the system to facilitate quick dispensation of justice. Do you agree with him, and also juxtapose that with what the Attorney General of the Federation has reeled out about some of the reforms and the progress they've made in the administration in the last 3 years?
Now, let me reiterate that no doubt there have been some improvements, legislative, administrative, and otherwise. Some of the figures the Honorable Attorney General gave, and they are not aware of them. I'm glad to hear them. But a point has to be made. Kazim talked about a judge in Oyo State having 300 cases. It goes beyond that. You may appoint 100 judges and they still not be enough. It goes to more fundamental issues. Now, Nigeria is probably one of the few countries in the world where you drag a man to court over a frivolous claim, you lose, and the court says it's against public policy to award cost. Now the man had to engage a lawyer, spend so much time defending himself or herself, and then you walk away free, probably with a cost of maybe 10,000. In some other claim, you have to bear the person's legal fees. Now we have to check whether this number of cases we have in our court is not a function of people feeling you can just bring any manner of case to our court and nothing happens to it. Now you also have to look at certain kinds of cases ought not to be in the courts. The AG talked about ADR mechanisms. Lawyers show a great unwillingness to use them. And our Arbitration Act needs to also be looked at to bring it in sync with modern realities. Most times when you get an award, people go back to High Court and start all over again as if they're litigating it. and go all the way to the Supreme Court, unlike in the UK and some other countries where there are narrow grounds for courts to intervene in arbitration matters. So it is not a case of large number of judges. It's also a case of what kind of matters get to court. What burden do people bear for bringing cases that ought not to come to court? How in some other places too, you must show what efforts you have made to use alternative dispute resolution mechanism to resolve the matters before you can get to the court. To what extent can lawyers and litigants be compelled to try that before assessing the cost? Because that's why the dockets of court, some of the cases on the court docket with due respect ought not to be there. They are frivolous. People just sue. For example, a person is owing a bank. There has been a default in making that payment. The bank wants to call in the loan. The person suddenly runs to court to say they want to sell my property at an undervalue. And because it just merely brings this action to frustrate the bank's right to recover the debt. And the lawyer knows this. But the court has to entertain it and give a decision. The court cannot at that stage say, but you're owing. Why are you doing this? And then nobody gets punished. Not the lawyer for bringing a case to court that ought not to be in court. No, the ethical issues involved, no professional misconduct issues are made out of it against the lawyer. And I think there has to be a judicial attitude that punishes people for bringing cases to court that ought not to be there. Lawyers for failing to know that certain cases ought not to go to court, that they amount to misconduct, and referring them for misconduct, imposing costs even on counsel where the delays are caused by them. And now that we are talking about constitutional amendments, we should also seriously consider having appeal courts at the state levels that make sure that certain state matters do not get to the Supreme Court. That matters that go beyond the appellate level of the state that can go to the Supreme Court are only cases that raise serious constitutional issues on which the courts have not made pronouncements. That's why cases can stay 10 years before they may be heard at the Supreme Court. So because there are just too many. And the Honorable General also talked about commercial transactions. Yes, we have made improvements on the administration of criminal justice. The cases take less than 2 years to come to trial. But the commercial transactions take a longer time. And no foreign investor would want to do foreign direct investment in an economy where disputes are not easily resolved, where they do not have confidence that they will not be bogged down on technicalities or having issues, commercial disputes quickly resolved. You want to know that where disputes arise, that they will be easily resolved. So they all go along. When I talk about this issue, it's not to say that we are in a state of anomaly or that we have gone back, but that we need to look at these areas, because unless we get it right in all these spheres, when we are sure that lives and security of people matter, and that disputes can be quickly resolved, and that people cannot get away with bad behavior, then until we do this, the picture of rule of law will not be complete.
All right. Thank you very much, Mazi. You've raised a number of points, and we would like the other guys to also, ventilate their views with regard to some of the propositions you've made. Let's bring in now Masood Alabelewe. A number of points that Mazi raised. In the first instance, it was talking about, we've heard this in the past, say, hey, listen, let's have the appellate court restored at the state level. We had them in the years past, and I think that they were all collapsed into the federal system sometime in 1976 or thereabout. It also talked about the role of the bar in some of these vexatious actions that we see that clog the courts. What's your reaction to this?
Yes, I must agree that more than 70% of cases that find their way to docket of the courts need not be there.
All right. Sorry, Mr. Alabelewe, let's just a minute. We'll pause you in the meantime, and we'll pause. Let's go back to our Ibadan Network studios. Kazim Badamosi, if you can hear me. All right, now that you're back on the screen there, on the split screen. The issues that I posed to our learned friend here, Alabelewe, I would like you to speak to them. One, the role of lawyers, in clogging the courts with sometimes vexatious actions, and also, the proposal that's been in the air for a while now for the return of the Court of Appeal at the state level to deal with state matters rather than proceeding to the Federal Court of Appeal and then thereon to the Supreme Court.
Well, that's in itself has several steps and several perspectives. There are several perspectives to it. Fine, if you look at the olden days, that is before 76, we have the days when we had regions. Those were days when you had Court of Appeal for the Western region, for the Eastern region, But the issue is still this. We had the Court of Appeal for the regions then. We now have state. We now have a federal government. There are states and federal government. All we have to do to make things work is we can have Court of Appeal in each state if that will hasten the dispensation of justice. Without necessarily saying go back to the states to have this Court of Appeal in the states, you can have Court of Appeal in each state. And where there are several cases, where cases that there are states that has a number of cases, you can have 2 courts, 2 panels, 3 panels, depending on the cases emanating from each state. And that is determined by the president of the Court of Appeal. The other aspect which I feel we have actually not touched or talked about is, you see, in certain instances, you need the leave of the court to go to the Supreme Court. The Court of Appeal has the power to say, no, we are not granting you leave. Because the issue which you are bringing up is settled. It's a settled law. There is nothing which you are going to do again in the Supreme Court. The Supreme Court itself can also refuse the leave to say, this issue has been settled in several cases. So, where the court itself is not taking not taking the bull by the horn, you cannot say the lawyer that has filed frivolous application. If you file and the court says, no, we dismiss your application and we award the cost of so much against the litigant himself will be very worried when next is advised to go before the court. So it has to do with the cases which we file and the way the court itself that has the power to refuse leave to appeal to Supreme Court on frivolous matters refuses the application. Where they do not refuse, of course the Supreme Court will get jam-packed. The Court of Appeal itself will get jam-packed. Even if Court of Appeals are created in states, it will still be the same thing because they will still have to go to Supreme Court too. There will still be the constitutional provision that they can appeal from the Court of Appeal to the Supreme Court of the states. And that in itself will not sort the issue or the problem which is on ground. The problem on ground is, do we have the requisite number of judges at the appellate court to handle matters coming from the High Court? And then is it in all matters that they can, as of right, file an appeal to the Supreme Court? That is an aspect of it. As regards counsel who dilly-dally or file frivolous applications, you see, it is unethical, which you must agree with. I agree with Mazia from Osigwe. It is unethical for anybody to file an application which he knows is frivolous or upon which there has been settled decisions. In such instances, of recent, the Supreme Court awarded costs personally against a counsel for filing a frivolous application. I think that probably was to serve as deterrent to others. But be that as it may, the issue is it unethical for you to file frivolous application? I agree it is unethical. But the delimitation of what is a frivolous application is what has not been set out. What you regard as frivolous application. And that is where I will say that for every proposition, what you consider to be frivolous, the person who has filed it might also probably have a decision of a superior court which backs that frivolous application. So he is justified. He feels, oh, I have seen a Supreme Court decision which says I can do it this way. Then in the light of that, will you say it is frivolous? What we need actually is this. There must be computerization of our judgments. And there must be consistency in the judgments which is passed out by our appellate courts. Once we have that, then you'll be able to determine without any fear that this application is frivolous. But when you have a judgment saying A is right, another judgment saying B is right, and there are 2-2 or 2-3, the man who has read 2 might not have read the other 3. So he might be right in saying what I have filed is not frivolous because of what he read. And that is where the issue of, and the Attorney General is the one that probably might assist the country in that regard. In ensuring that whatever judgments we have of the appellate courts, especially the Supreme Court and the Court of Appeal, are synchronized and are computerized so that there will be consistency from the judgments of the appellate courts. There is a need for us to have consistency, and once we don't have that consistency, it has to do with telecom. It has to do with internet facilities, and it has to do with electronic recording and a host of other things, which will assist the judiciary to have consistency in their judgment. Once you don't have consistency in judgment, you cannot say applications are frivolous, except that person has come to court without being supported by a particular judgment of an appellate court.
Kazim Badomasi in our Ibadan Network Studios. We'll come back to you again. Let's bring in quickly Masood Alabelewe. We're looking at the issue of certain cases getting to the Supreme Court and alternative ways of resolving some of the disputes we have now. Should we allow most of the cases that get to the Supreme Court go that far? Are there better ways of handling them?
Yes, when somebody complains of a breach of his rights and he goes to the court of first instance, he perceives that he didn't get justice, he goes to court of appeal, he perceives he has not gotten justice, he has a right. But what everybody is saying is that maybe the Supreme Court or the Constitution could be amended to make certain provisions that will, reduce the number of cases that goes to the Supreme Court. Say, for example, in other climes, some people have suggested that in other climes, cases that goes before Supreme Court are actually with leave of the court. So before you list a case before the Supreme Court, you must obtain leave that, yes, this case is worthy, is something that we could hear. But more than that, I want to believe that most litigants these days, their minds may not have been made until they meet a lawyer. And they get emboldened when a lawyer tells them that this is doable. So our colleagues, should actually consider the situation of the country and the workload of the judiciary to ensure that only cases that are genuinely, seriously necessary for the courts to listen to are the kind of cases that go to court. I must agree that there are quite a number of things that could be done to resolve disputes alternatively. There are matters that, it's a matter of very, very streamlined matters that are, okay, for example, bank matters. Somebody is owing a bank and he has, given a security or a facility of his property and he defaulted. And he rushed to court to say, no, they want to sell my property. Now, most of our colleagues will say, no, we just went there to buy time. And I tell them that, what time are you buying? Because interest element goes on, because if a lawyer works his claims very well, the interest continues as far as the matter is in court. And in fact, if you are actually buying time, couldn't you have approached the bank or approach whoever is concerned that let us do it like this, let me work as fast as possible to bring this debt to this level. And in fact, because of the fact that they know the peculiar situations with the court, that's why lawyers find it very convenient to do that kind of thing, to say buy time in court. In fact, sometimes some people will tell you, go to court, we'll meet there, knowing that when they get there, they're just trying to I've participated in cases where even the plaintiffs are not even ready to proceed because they went to court with a different intention. So some of these things are the things that culminate to the kind of things that we have in the judiciary. And I must say it, that talking about improvements that we have seen, there are a lot of things that are going on in the judiciary. Lots of judges are really, really encouraging and ensuring that cases are heard expeditiously. There are judges that we know that when you are going before them, you better be ready. If you are not ready, you know the judge will descend on you and give you whatever you deserve, and that they will not allow cases to pend in their court unnecessarily.
All right, thank you very much. But very quickly, let's go over to our viewers who have sent in their observations using the Twitter handle that we have here. Olowokere Olajide has this tweet. Effective implementation of our laws for socio-economic development can only be achieved if the diligent and hardworking judicial officers are rewarded by the government and the people.
And this one is coming from Henry Chubuike Ugu. Shortcomings in the administration of justice in Nigeria are enormous. There's need to inject integrity in all the subsystems of the justice system, prosecuting agencies leave much to be desired in conducting their cases, and appointment of judicial officers seem not to be on merit.
Sonny Michael Amakoji tweets, Honorable Minister of Justice, why is it that stay of execution allows offenders to stay in office more than necessary, even when it's glaring that the suspects are guilty? Can this old form of practice be changed? If possible, how soon are we expecting that? Can there be a case of glaring, glaring guilt? It has to be pronounced by a competent court of jurisdiction.
Now, let's take this one from Habila Kwara Zakshi. The administration of justice in Nigeria and the justice system needs to be amended, particularly as it concerns the common man that cannot afford someone to stand in for him. Do you know that in Nigerian prisons, there are innocent people kept up to 5 years?
Mike Anyankwo tweets, now the administration of justice is at a trying period in Nigeria. We have witnessed a lot of rot in the system. For instance, lawyers allegedly colluding with some judges to subvert the justice. We have also witnessed the arrest, prosecution, and dismissal of some judges on corruption charges. We must cleanse the system.
And Suleiman Zuntu tweets, the application of rule of law in Nigeria must be in line with judicial reforms, because laws are meant to be dynamic in order to strengthen the judicial system. Otherwise, even the due process may constitute a setback in the fight against corruption.
First, let me take this from Dele Jack Solomon now. It says, there is need to educate lawyers on how to provide fair, timely, accessible, and equal justice for all Nigerians in an efficient manner, regardless of the economic, political,